members of the committee. My name is Brandon Logan. I'm a senior fellow for Family Freedom Project, a statewide advocacy organization that works to defend parents' rights. In course in the legislature, I'm also testifying based on my experience as an attorney. I was one of the first child welfare law specialists in the state of Texas, speaking in strong support of House Bill 2071. The bill simply says that a person's name can't go on the child abuse and neglect registry unless a court of competent jurisdiction finds that abuse and neglect occurred. Today, a DFPS investigator alone makes a finding, and that finding is sufficient to place a parent on the child abuse and neglect registry. There is no requirement of court involvement. This is just an internal administrative decision. Notice of this finding is supposed to be sent by first-class mail, but it's often never received. I had many cases in attorney where a parent never received notice of finding and didn't know they were on the registry. When they do receive it, it's this very benign document that certainly doesn't indicate that your life is forever impacted by the fact that you've been placed on the registry. I have represented parents who have had children returned by court order due to insufficient evidence, but yet they remained on the registry. I'm thinking specifically about a mother whose child had severe eczema, but it was treated. She was accused of medical neglect. We had the doctor, her child's doctor, testify at the at the 14-day hearing, and that child was returned. However, the mother was on the registry, and I had to represent her in getting her off the administrative review process. That is not paid for by the state. I did that pro bono. That was one of the cases I did pro bono in order to get her off. I've also had clients that discovered they're on the registry years later whenever they applied for a vocational program. They didn't even know they were investigated, let alone did they know that they were on the registry. This is a process that can destroy careers and reputations and futures without adequate due process. This bill just closes a constitutional gap. No one should be blacklisted without judicial review. This just aligns with how we treat other serious designations under Texas law, like criminal convictions and protective orders. The CPS process is unchanged. CPS still investigates, they still remove children, and they still can take emergency action. This bill doesn't touch that. It only affects the permanent labeling of individuals after the fact. Thank you for your time, and I'm happy to answer any questions.